When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-first acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute.
No matter how minute.
Who comes to equity must come with clean hands. Hello, my beautiful and wonderful viewers. You are welcome to another fresh episode of the program Justifying Nigeria on ACNN television, reaching you from Abuja. On today's episode, our subject will be the preliminary of the law of evidence. My name is Anozechi and I'm so your anchor. The law of evidence forms the very basis upon facts approved or disproved in any judicial proceedings. It is the will upon which the judicial proceedings ride in the court. Hence, cases are won or lost in judicial proceedings based on the sufficiency of evidence or lack of it in proof of facts in issue or facts relevant to the facts in issue. However, for one to be abreast of the law of evidence, there are basic and fundamental preliminaries that an individual must be aware of. What are those preliminary matters? How can we x-ray and dissect the law of evidence for the better understanding of all? What are the scope and sources of the law of evidence? With me in the studio to make sense of it all is Barrister Obi Nonya, who is a senior associate at Dr. Nyechi Bazu, SAN and Co., member Chartered Institute of Arbitrators, and also an Abuja-based legal practitioner. Counsel, you're welcome to the program, sir.
Thank you, sir.
Thank you very much.
Thank you, sir.
A lot of evidence, you agree with me, is a very technical and, robust aspect of law. That you must be very careful. Yes, what did you make a point?
It's at the heart of,
that's
the heart of every adjudication.
In fact, the heart, we had the blood of adjudication comes from.
Yes.
So without evidence, no case.
That's the basis of which, that's the basis where parties' rights are determined.
That's right.
On evidence.
So now, to elaborate from what you've just said, to the better understanding of our viewers, what is law of evidence? What is evidence?
Okay, so evidence is the fact upon which parties' rights are adjudicated, or the set of facts upon which the rights of the parties are determined. So, for you to determine whether a person in criminal proceedings is guilty or not guilty, in civil proceedings where a person is liable or not liable, then it is upon an appraisal of the evidence, that is the set of facts which has been presented before an arbiter, a judge, a court, a magistrate, and then the application of the law to those set of facts to now tilt the balance of the law one way or the other.
So you mean speculation cannot be an evidence?
No. It must be fact. In fact, the Evidence Act is like a handbook, okay? It's like a guide upon which to determine what we'll call fact. Because that we say fact does not mean it is fact. Fact is what the Evidence Act has called fact.
Facts.
So when a person says a thing, for instance, the question is, when you now put it under the crucible of the Evidence Act, does this constitute what we call fact?
According to Evidence Act.
According to the Evidence Act. So a person may say, oh, this thing exists. But when you now pass it through the Evidence Act, you see that it falls short of the requirements of the evidence. For instance, when a person says, they told me that he killed the boy. Okay? Now, under the Evidence Act, there's what we call hearsay evidence. Hearsay evidence is that I did not see or I did not perceive with any of my senses, but somebody gave me that information. Under the Evidence Act, hearsay, that's a general rule, there are exceptions, hearsay is inadmissible. So when you are saying, I was sure she told me, okay, that does not constitute admissible evidence, or it is not fact upon which a court can rely upon. So that kind of fact, for instance, that person who told you must come before the court and say, I saw, okay, or I perceived with any of my senses that incident. That is when you will now say that evidence is not hearsay and a court can rely on it. So, and every evidence placed before a court must be in such a way that a court can rely on it and then apply the law to it.
Thank you very much. It then means the court must have to know about it based on the concrete evidence established and gone through the process of the Evidence Act.
Exactly.
It then means Evidence Act form like a ground norm as long as adjudication is concerned.
Yes.
In fact, it's just like a Bible as Christians and that of Quran in Muslims. So when it talks about evidence, Evidence Act must be the key to direct.
So the law that governs evidence generally is the Evidence Act 2011. So it's the Evidence Act that has, like I said, like the handbook, and it now shows us the procedure, how to go about calling something evidence, even calling of witnesses, even the procedure for hearing, and then determining when the person has been given a fair hearing. So under the Evidence Act, they will say when a person comes to give evidence, he will be examined in chief. That is the person who calls him. We allow him to tell his story. The Evidence Act now provides again that after he tells that story, he will be cross-examined. That is, that story he has been told. Somebody will now put questions to him to test the veracity of that story he has told. And then he will now be allowed to be, the person who called him will now re-examine him. So for an evidence to be accepted, it must have gone through that back and forth process to test the veracity of that evidence. So if a person who is called to give evidence doesn't pass through that process, then that evidence cannot be accepted.
Thank you very much, Counsel. Then, what are the scope and sources of this law of evidence?
Okay, so the source, like I said, is the Evidence Act 2011. That is the source. Then the scope. You see, the issue of scope is not set. Okay. Then let's start with what is certain. Every court of record. The Evidence Act 2011 applies to every court of record. Court of record will mean High Court, Federal High Court, Court of Appeal, Supreme Court, tribunals like election tribunals and all. Those ones it applies. However, like in arbitration, the Arbitration and Conciliation Act says that the Evidence Act does not apply to arbitration.
For real?
Yes. However, the rules of evidence applies. I'll explain again. The Evidence Act does not apply to arbitration.
That document you told us that, is the handbook. Does not apply?
The Evidence Act 2011 does not apply to arbitration. However, the rules of evidence, what are the rules of evidence? I summarize it in one word: fair hearing. Okay? So in the conduct of arbitral proceedings, you will ensure that the parties are heard fairly. But as to say that this section of the Evidence Act has not been complied with, no, it doesn't apply.
So you can't quote section something of Evidence Act in that
as a binding law. No, you cannot. Then in the Sharia courts and the customary courts, the Evidence Act also doesn't apply.
In Sharia court
They
and
don't.
customary
They
court.
don't. So those courts is also the rules of evidence that will apply. So you can't start citing the Evidence Act to say, oh, this document is not admissible, oh, this document is admissible. No, you cannot do that. So it's the rules of evidence that apply. But in superior courts like the High Courts, election tribunals, Court of Appeal,
Supreme Court, Industrial Court,
National Industrial Court,
Federal High Court,
the Evidence Act applies fully. In the National Industrial Court, no. In National Industrial Court, the wordings of the NIC Act is rules of evidence, or the Evidence Act is not binding.
Okay, in the
National Industrial Court, yes. It's funny enough. You see, I naturally said, oh, National Industrial Court, but no, it's not. So you can't hold on to sections of the Evidence Act at the National Industrial Court.
This is becoming interesting.
Yes.
You continue when we come back from break. Please do join us again. Hi, you are welcome to the speaker on ACNN television, reaching you from Abuja. On today's focus, we are going to be looking at the phrase or topic that says progressive Nigeria or progressive Nigeria. My name is Anozechi Nomsu. Being progressive is an advancement towards good policies and ideologies that will better the lives of people. This simply means that when one is progressive, it is expected that a desired and positive result should be produced. When a nation is progressive, one expects a good and sound education, solid healthcare system, better infrastructure, maximum security of lives and properties, adequate and conducive environment for creativity and innovation, stability of good political leadership, strong and healthy economy. On the other hand, when the above positive ideologies and agenda are lacking in any society or sovereign states, that society or sovereign state is unprogressive in nature. With the current state of Nigeria, where all of the above mentioned dividends of democracy is totally absent, I'm persuaded to ask on whether we are living in a progressive Nigeria or an unprogressive Nigeria. Nothing seems to be working in Nigeria. Sound educational system not working. Strong economy, 0. Stability in power supply, -1. Strong agenda and healthy governance policies, not present. There is absolutely nothing that is working in Nigeria because we have unprogressive political leaders occupying positions of leadership in a progressive Nigeria. I do not know whether to laugh or cry. Just recently, Association of Thief People in America, known as the Mutual Union of Thieves in America, MUTA, wrote a petition to the National Assembly in order to raise awareness to the pitiable condition of their people in Nigeria, where their people are being killed by bandits on a daily basis, their women raped by Fulani henchmen, their farms destroyed, and other negative and unhealthy things happening in their ancestral land. The petition was brought on the floor of the House of Representatives through Honorable Mark Biller, member representing Owe East and West Federal Constituency of Benue State. To my greatest shock and that of the world, the Deputy Speaker of the House of Representatives, in the person of Ahmed Idris, rejected the petition on the basis that the petitioners are not residing in Nigeria and that Nigerians in diaspora has no say in what is happening in Nigeria. What a shame. Ahmed Idris has forgotten that these petitioners are Nigerian citizens. He has forgotten so soon what Chapter 3 of the 1999 Constitution of the Federal Republic of Nigeria talks about citizenship. I thought as a lawmaker that he claims he is, he would have referred to the sections 25, 26, 27, 28, 29, 30, 31 and 32 of the 1999 Constitution of the Federal Republic of Nigeria as amended in order to guide and guard himself on what to do when such issues is confronted to him. That is what happens when we have unprogressive Nigeria. That is what happens when some positions in Nigeria are filled with baron and cabal of incompetence, with kleptomanic fingers and sucking filaments, stealing our collective joy. Nigeria must wake up and have a rethink on the caliber of people they elect into public office. Else, we shall one day be in the cusp of the sin and disgrace of Ichabod, which only the womb of time will tell. I therefore speak. Until Nigerians wake up from their slumber and realize that the power to change things is in their hands and not the political leaders, and thus exercise that franchise wisely, honestly, and competently in order to elect good men and women into political offices, we shall continue to have unprogressive Nigeria instead of a progressive Nigeria. My name is Anozechi Nomsu. I just want to speak. Hello, glad to know that you are still there, and we are still here in the studio with Barrister Obi Nonya. Now, Council, before we went for break, there was this thing we are trying to, isolate and clarify. You said that the National Industrial Court, that a lot of evidence does not, that's the Evidence Act, does not apply.
Yes.
Please take it from there.
Okay, so the act creating the National Industrial Court specifically provides that the rules of evidence are applicable, just like I said, in a customary courts, in Sharia courts, in arbitrations, but the strict application of the Evidence Act does not apply to the National Industrial Court. So what applies there is rules of evidence. When you say rules of evidence, fair hearing,
on those
the
fundamental
procedures
things
to ensure that justice is done.
Is done. But other, of course, Superior Court, High Court, Federal High Court,
it fully applies.
It fully underlies. Now, Council, is law of evidence essential in both civil and criminal matters?
Yes, it's essential in both. You see, like I said, to determine the rights of individual, it is the evidence that is placed before the court that determines a person's rights, and that determines how the rights are determined. Because what happens in adjudication, in everyday court proceedings, is that the evidence is led. Okay? By evidence, we mean the facts are presented before the court. Now, those facts must be presented in accordance with the handbook or the constitution of evidence, which is the Evidence Act. Now, if that fact is not placed in consonance or in tandem with the Evidence Act, then they will say that fact, that evidence is not admissible, and a court cannot work with inadmissible evidence. So a person who brings something before the court, you must now place it before the court. In a day-to-day litigation, we say you now tender it before the court. When it's tendered, it is now admitted in evidence and marked as exhibit. So when it is tendered, it is marked as exhibit. If it is tendered but rejected, then a court cannot rely on it, because a court can only work with documents which have now been baptized and called exhibit. If that document is not called exhibit, then a court has no business going outside what is placed before the
legal
court.
baptism, I love that. So even in court, they baptize, of course,
so
becomes an exhibit.
Yeah, so when a document is tendered, it's either marked exhibit or marked as tendered but rejected.
Okay. It must go to the court, a record of the court that tendered but rejected.
So a court has no business with documents marked tendered but rejected. A court has no business with documents not tendered at all. So it is when those exhibits are now placed before the court, maybe physical evidence, maybe a gun, documents, and then the oral evidence, which is given viva voce from the witness box or reduced into an affidavit form. Then the court will now look at those exhibits or those evidence and then apply law to it. Okay, so it's the application of law to fact that is adjudication. Application of law to fact. So a court cannot apply law to fact, to what we have not accepted as evidence or fact. Okay, so a court must only apply what has been accepted. It cannot go outside the scope of what is accepted.
Because I was about to ask you to explain what you mean that apply law and fact, so that you don't get our viewers confused.
Okay, for instance, there is an allegation. Somebody says he saw, and a document is produced. Now, with that, those sets of facts placed before a judge will now say, from this fact, I am convinced that this thing transpired. Then the judge now says, what is the consequence of this thing that transpired? He goes back to the law. So it is those sets of facts that the law will be applied upon to now determine how parties' rights will swing one way or the other. If the judge says that from this set of facts, the ingredients of an offense has not been established, because every offense, for instance, in criminal litigation, has ingredients. Every soup has ingredients. So the law, a court must now satisfy itself that those things that constitute an offense is present for you to now apply the law to say this person is guilty of this offense. But if the court has looked at those the evidence which has been placed before it. I say, from what I have seen, the ingredients to constitute the offense of X is not before me. Therefore, the person is acquitted. The ingredients to constitute the offense is before me. So what is the consequence? You put the punishment. Okay. So what the court does is he now appraises what has been placed before it, vis-a-vis the charge if it's in criminal cases, vis-a-vis the statement of claim in civil cases, and now say what is the consequence of this thing that has been placed. So from the statement of claim from the charge, the court will now be able to now direct itself on the consequence.
Thank you very much, Counsel. Now, Counsel, I know that in criminal law, that the evidence is based on proving beyond all reasonable doubt. Then in civil is the issue of preponderance of evidence. I don't know what I'm correct.
Yes.
Can you now just suppose that I explain that very
so beyond
that.
reasonable doubt is not, they'll say it's not beyond all shadow of doubt, but it's a burden, which I would say a reasonable man placed in that shoe is convinced that this is convinced to some certainty, let's say 70%, that this incident occurred. Okay? Now, preponderance of evidence is more like a 51-49 situation. Okay? I put it on the scale.
Weighing scale.
Okay?
Yeah.
And I am inclined to believe this to this. Okay? So that is preponderance of evidence. It is more probable. Okay, probability. Okay, so in civil cases, a judge does not need to get to the standard of beyond reasonable doubt, but the judge must get to the level where he says, this A story is more probable to be. I'm inclined to believe A to B based on the sets of facts that has been placed before me. However, because in criminal cases, we're talking about the rights, civil rights, and the liberties of individuals, then the scale is now raised higher to beyond reasonable doubt. So beyond reasonable doubt is that every reasonable man placed in the shoe of an arbiter will be convinced that this actually took place or this is actually the position. So beyond reasonable doubt is a higher burden than preponderance of evidence.
Thank you very much, Counsel.
Thank you, sir.
Now, we know that court is the final thing. Of course, when you bring a matter to a court, you expect the court to do justice to that. Now, can the court sumato, sumato on their own, adduce evidence? If yes, will it not be amount of the court being biased or partial? Or what happens in that circumstance?
Okay, so
you get the question.
I get the question. So
yes.
In Nigeria, we have what we call Nigeria is a common law country, and a judge as an arbiter does not go on a fact-finding mission. Okay, in common law countries, the judge sits back, and as much as possible, in legal parlance, they'll say the judge does not descend into the arena of litigation to source for evidence. No, the judge should stay back and receive evidence. A judge does not go on a fishing expedition. A judge does not go and solicit or look for evidence. A judge does not even put questions to witnesses. A judge should stay back and receive the evidence from parties. So a judge cannot descend into the arena to cross-examine or to elicit or solicit for evidence. No. However, in civil law countries like in France, a judge is a judge goes in search for truth. Okay, so in such countries, it's accepted for a judge to descend,
go out of his way,
to put questions, to interrogate, to source for information. Okay, but in civil law countries, the judges have been advised several times to be more neutral, to be more to sit back, okay, and receive the evidence. The judge can throw hints here and there, but it's usually advised for a judge to take his place
as a judge
and allow the parties do their case.
Thank you very much. Then in less than a minute, then what happens when a proper evidence is not properly tendered? Just in 1 minute.
So where evidence is either not properly tendered or not tendered it goes to no issue. Therefore, there is nothing before the court. A court's hands are, like you used earlier, a court's hands are tied. A court cannot make an inadmissible evidence admissible. So a court cannot rely on it. No court should rely on improperly or an untendered document.
No court relies on improperly evidence or the one that is not properly tendered. We want to appreciate you, sir, for coming. Thank you very much for doing justice to all this.
Thank you, sir.
The importance of evidence in any judicial proceedings, whether civil or criminal, cannot be overemphasized. This is because without evidence, the hands of the court are tied, as the court must act on evidence and evidence alone, and not on hunches, rumors, or speculations. This was the decision of the court in honor against the state. 1985, 3 Nigeria Weekly Law Report, Part 12, 236 at 244. It is wrong to arrest and file charges against suspects before looking for evidence. It is therefore advised that the law enforcement agents or officers must have concrete evidence before arrest and detention are made. Finally, the judge has no business in searching for evidence in support of the case before him, for that is entirely the duty of the parties and their legal practitioners. The judge only acts on the evidence presented in support of the fact as alleged by the parties. This is in pari material with the decision of the court in Rimi against INEC, 2005, 6 Nigeria Weekly Law Report, Parts 920, 56 at 84, that where no evidence is led to establish the claims made before a court, such claims will be dismissed for want of evidence. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, my name is Sanoze Chinum, so saying bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.